Case that could determine if firearm accessories known as bump stocks violate federal law.
The Supreme Court is hearing arguments on the Trump-era ban on bump stocks today.
Bump stock was banned by the Trump administration in 2018 after playing a role in America's deadliest mass shooting.
A majority of them believe that the gun accessory makes a weapon an automatic rifle.
That's the argument with bump stocks. All they do is allow you to pull a trigger many times faster than a human normally could.
To propose regulations to ban all devices that turn legal weapons into machine guns.
Safe from legal automatic weapons. During a Supreme Court argument on Wednesday morning, Justice Amy Coney Barrett told Brian Fletcher, the Justice Department lawyer defending a ban on devices that turn common semi-auto weapons into much more lethal arms capable of firing very rapidly, "Intuitively, I am entirely sympathetic to your argument." That suggests that Barrett, a conservative Trump appointment who occasionally deviates from her fellow Republican justices in arm issues, will maintain the prohibition on these gadgets, also referred to as bump stocks. Currently, there is a sharp disagreement among lower courts on whether the federal ban on mash guns is wide enough to include these bump stocks. Many Republican appointees have interpreted the law narrowly, while many Democratic appointees have taken a different stance. Barrett made a few inquiries that gave rise to the possibility that she would break through this partisan impasse and support the more liberal branch of the judiciary. Barrett, however, and Chief Justice John Roberts, another appointment of the Republican Party who occasionally goes against the grain, otherwise kept their cards close to the vest. Jonathan Mitchell, the attorney challenging the prohibition, made two arguments, the weaker of which Roberts seemed indifferent to. The chief, however, did not address Mitchell's more persuasive one. Furthermore, Barrett's inquiries mostly focused on fairly specific data regarding the operation of bump stocks. Thus, if you had to wager on the outcome of this case, Garland versus Cargill, you ought to place your money on the bump stock ban being maintained. However, you also shouldn't be overly optimistic about the outcome of your wager. Interpretation of federal statute. Except in certain situations, civilian ownership of mash guns is prohibited under federal law. As per the definition, a mash gun is any weapon that has the ability to shoot multiple shots automatically without the need for manual reloading, all with a single pull of the trigger. Contrarily, a bump stock is a piece of equipment that makes semi-auto arms made to discharge a single round each time the user presses the trigger, look like fully automatic weapons, which are made to discharge a constant barrage of bullets. Due to the arm's recoil, bump stocks cause the trigger to continually buck against the shooter's finger, causing the weapon to jolt back and forth. In 2018, following a gunman's use of a bump stock to murder 60 and injure hundreds more at a country music festival in Las Vegas, the Trump administration enacted a regulation outlawing them. However, there is disagreement among federal courts regarding whether bump stocks fall under the statutory ban on automatic weapons reference to a single function of the trigger.
Case that could determine if firearm accessories known as bump stocks violate federal law.
To gun enthusiasts, it's a toy for having fun. To safety advocates, it turns a weapon into a killing machine.
The Supreme Court is hearing arguments on the Trump-era ban on bump stocks today.
To propose regulations to ban all devices that turn legal weapons into machine guns.
A few justices came to the conclusion that this reference to a single function of the trigger should actually be interpreted as a single pull of the trigger from the perspective of the shooter, including two judges on the left-leaning United States Court of Appeals for the District of Columbia Circuit. Because the shooter engages in a single pull of the trigger with her trigger finger, and that action via the operation of the bump stock yields a continuous stream of fire as long as she keeps her finger stationary and does not release it, the court declared that a semi-auto arm with a bump stock qualifies as a mash gun. Some judges, including many on the far-right Fifth Circuit, interpreted the act differently, highlighting the fact that even in the case of a bump stock, the shooter does not need to take any more action for the arm's trigger to move multiple times. The Fifth Circuit judges stated that the fact remains that only one bullet is fired each time the shooter pulls the trigger, despite acknowledging that bump stocks enable semi-auto arms to fire extremely quickly. Both of these legal views are tenable when analyzing the wording of the statute. Therefore, the Supreme Court must decide between these two interpretations of a vague federal statute. Arm control laws and innovative engineering. Arm control advocates have a recurring issue as a result of the Cargill case. Whenever Congress passes a law outlawing almost anything, it usually has to specify exactly what the bill forbids. Therefore, arm manufacturers often attempt to create a new device that performs exactly like the prohibited item but does not fall under the definition of the banned device when Congress bans a certain type of arm or weapon accessory. They accomplish this by looking at the statutory definition of the banned device. The Supreme Court resolved a case resembling this one last August because the issue comes up so frequently. In order to get around federal rules governing more immediately operable weaponry, so-called ghost arms, or weapons that are sold in kits that are easily assembled but are disassembled, were involved in that case. Remarkably, in that case, known as Garland versus Vanderstock, Barrett and Roberts concurred with the 3 Democratic appointees on the court to uphold a federal regulation that forbade the sale of phantom weapons. Justice Sonia Sotomayor, meanwhile, offered a possible extension of the Vanderstock ruling to comparable attempts to circumvent arm control legislation by inventive engineering during the oral argument on Wednesday. She made the point that the Supreme Court has long cautioned against interpreting vague legislation in a way that makes them ineffectual, citing the extremely old case of the Emily and the Caroline. The court stated in the Emily that we must look at the object in view and never adopt an interpretation that will defeat its own purpose if it will admit any other reasonable construction. This rule applies to both penal and non-penal legislation interpretation. However, it was uncertain if Barrett or Roberts were willing to challenge the actions of arm makers to circumvent law as far as Sotomayor went. Barrett did raise one potential avenue for the government to win this case without delving into the more significant question of whether arm control laws should be interpreted broadly to prevent sabotage. The main point of contention throughout the debate was that not all arms had conventional triggers, which are metal levers with curves that the shooter must pull in order to activate the weapon.
Today, that they say there is a manual operation by the shooter and it is not automatic.
About whether bump stocks are a good idea. This is really a classic example of sometimes Congress is stuck with the words it uses.
I mean, really, Vlad, this is a case to me. It's not a Second Amendment case. No one's arguing that you can't ban bump stocks.
Bump stock was banned by the Trump administration in 2018 after playing a role in America's deadliest mass shooting.
The justices also appeared to concur in principle that an automatic weapon meets the federal definition of a mash gun, even if it fires by way of a non-traditional trigger like a button or switch. Bump stocks alter the way a shooter sets fire to an arm, much as an arm like that with an unusual trigger. To start automatic firing, the shooter must keep their finger on the trigger and continuously press forward on the barrel as opposed to just pulling on a curved metal lever. Barrett questioned whether, in drafting the regulation outlawing them, the government could have defined the bump stock itself as a trigger. That example, a semi-auto arm with a bump stock, could be conceived of similarly to an arm with an unconventional trigger, such as a button or switch, rather than like an arm with a typical curved lever trigger. Put another way, regardless of whether the weapon employs a more basic mechanism, if the bump stock is removed, the mechanism that permits the arm to fire once the device is placed serves as its trigger. Although Barrett's question about what qualifies as a trigger was brief and provided little insight into her thought process, it may be a preview of what she will eventually say if asked to write a majority opinion in the Cargill case, given her earlier remarks that she was sympathetic to the government's argument and her vote in the Vanderstock case.
Like a machine gun? Similar, yes, but not quite like that. You can take pretty much any semi-automatic firearm.
A majority of them believe that the gun accessory makes a weapon an automatic rifle.
Legal debate and potential outcome. Having said all of this, it was difficult to watch Wednesday's debate without feeling as though the bump stock ban will likely be successful. The attorney challenging the prohibition, Mitchell, is renowned for his hyper-formalistic arguments that, while comprehensible when examining a statute or legal doctrine in its most basic form, led to ridiculous and frequently disastrous consequences. In this instance, his reasoning followed that pattern, and he didn't help himself by repeatedly answering doubtful inquiries with the same responses in progressively patronizing tones. Furthermore, Mitchell did not strengthen his case by focusing on a point that none of the justices seemed to find convincing. Recall that arms that discharge automatically fall within the statutory definition of mash guns. Mitchell asserted that because the shooter must continuously apply forward pressure to the barrel, arms with bump stocks do not engage in automatic fire.
The Trump administration banned bump stocks after the deadly mass shooting in Las Vegas, and there have been legal challenges since then.
Firing rapidly, almost at the same rate as a machine gun, and that's why these will be banned starting tonight.
Including the Supreme Court has ever suggested that you got a Second Amendment right to own a machine gun.
That's the argument with bump stocks. All they do is allow you to pull a trigger many times faster than a human normally could.
However, no one believes that conventional automatic weapons do not fire automatically, since the shooter must continually apply backward pressure to the trigger in order to keep the arm firing. Regardless, Mitchell's argument was so poorly received by the justices that even the most dependable Republican partisan on the court, Justice Samuel Alito, cautioned Mitchell that he found it unclear and asked him to proceed with a new argument. Similarly, as Justice Brett Kavanaugh continued to probe Justice Department lawyer Fletcher with a number of highly suspicious questions, it seemed that Kavanaugh was growing increasingly doubtful of Mitchell's assertions. In fact, Kavanaugh devoted the last portion of the debate to raising doubts about any proof that the vague language governing a single function of the trigger, which is found in the federal law, was originally intended to depend on the precise details of an arms operation. Therefore, the tone of the argument suggested that the key justices were carefully considering Fletcher's attempt to address their concerns, and that they were growing increasingly frustrated by Mitchell's repetitious arguments and indignant tone, even though they did not expressly state how they were approaching this case. It remains to be seen if it implies the bump stock ban will be maintained. However, once more, it seems highly likely that it will. That's all for this video, folks. See you next time.